All right, everyone. My name is Megan Malloy. I'd like to welcome you to our last installment of the Constitution series. I'm going to introduce Michael Dorf, who is going to talk to us about birthright citizenship.
Hi, I'm Mike Dorf. Nice to see you folks today. And if anybody came to the first one I did a couple months ago, thanks for coming back. So I'm going to talk tonight about birthright citizenship, which of course has been in the news because of the executive order that President Trump signed on his first day of his current term. We'll get to that in a little bit. But what I thought I'd do first is give some background about citizenship under the US Constitution, and then I'll sort of take us all the way through the case. If you have questions like what I said or just clarification, feel free to ask during the presentation. Otherwise, I'll have a robust time for Q&A at the end. Okay, so just to give you an idea of what I want to cover. So first, just why citizenship matters. Talk about citizenship in the original Constitution before it gets amended by the 14th Amendment, which contains the birthright citizenship provision. The Dred Scott case, which is specifically overruled by the birthright citizenship provision. We'll then talk a little bit about the 14th Amendment itself. Then the key case is a case called Wong Kim Ark from the late 19th century. So leading up to that, I want to give you a little bit of the background on something called the Chinese Exclusion Act. Then we'll talk about the Wong Kim Ark case. I'll talk a bit about how federal statutes have incorporated the constitutional language and maybe the Wong Kim Ark decision itself. I'll then give you the Trump executive order and talk a little bit about some of the litigation against it, including the case the court decided earlier this year, not on the merits, but with respect to the scope of remedies. And then finally, I'll explain why, putting this all together, if the law is respected, the executive order should be held invalid, which is not a prediction. It's just I'm telling you what should happen. And then finally, we'll turn to discussion. Okay.
We want a prediction.
All right, I'll give you a prediction. Knicks are going to win tonight. That's my prediction. Okay, so why does U.S. citizenship matter? The first thing to note is that for some purposes, including some constitutional purposes, it doesn't matter. So this is the language of the 14th Amendment to which we'll return later. But you'll notice that, so I've highlighted in yellow the citizenship clause. That's the provision we're going to spend most of our time discussing. But I have also highlighted in green and purple two other provisions of the 14th Amendment. So the first is the actual phrase, citizens of the United States. But if you notice, what precedes that is a provision stating that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now that language also appears in the original Constitution in Article 4 and was probably adopted by the framers of the 14th Amendment for the purpose of making the Bill of Rights applicable to the states. It wasn't originally, but that was probably its original purpose. However, in a case that has come to be known as the slaughterhouse cases in the 19th century, the Supreme Court read the privileges or immunities clause very, very narrowly. So it effectively does nothing in modern terms. And that's actually a good thing. And the reason that's a good thing is that you'll notice that the privileges or immunities clause protects the rights of citizens of the United States, whereas the next two provisions, the Due Process Clause and the Equal Protection Clause, protect the rights of persons. And so rights under the Constitution are generally rights of persons. You don't have to be a citizen to have freedom of speech, to be free of unreasonable searches and seizures, et cetera.
So where's this quote from?
This is the 14th Amendment. This is Section 1 of the 14th Amendment. Right. So that's So that's one way in which citizenship doesn't matter. But there are some rights that extend only to citizens. Voting is the most important of these rights. You might think of jury duty as another, although most people think of that less as a right than as a pain. But it is associated with citizenship. The main reason why, as we're discovering recently, why citizenship, as opposed to, say, permanent residence status or some other kind of status, matters is because it protects against removal, right? So it establishes the right to remain in the country. That is the main reason why, I think, if you saw yesterday, the Trump administration announced that they are going to dramatically step up the number of denaturalization proceedings, that is, proceedings to strip people who are naturalized citizens of their citizenship. Now, the good news about that is that in order to do that requires actually going to federal court and not just to immigration court. So another story you may be following is how the Trump administration has been firing immigration judges. Basically, if an immigration judge had ruled in favor of asylum petitions, they got fired, and they've been replaced partly by military judges and otherwise by new immigration judges who are undoubtedly more sympathetic to the administration's position. Is that a question? Yeah.
It is interesting that it's for the nor shall any state deprive any person of life, liberty, or property without due process of law. So that would be any person, but what if the feds are the ones that are deprived?
Right, that's a great question. So this is the 14th Amendment. The same language already appears in the 5th Amendment, which is 1791, and that is a limit on the federal government. So, but you are right, and this is just a kind of fun fact, right? The 14th Amendment is a limit on the states. It's also a limit on local governments because those are creations of state law. It is not a limit on the federal government, except the Citizenship Clause, right? The Citizenship Clause doesn't say no state. But those other provisions, the Due Process Clause, the Equal Protection Clause, and if it meant something, the Privileges or Immunities Clause to some extent, right, would be limits only on the states. That doesn't really matter with respect to due process because you've got the same language in the 5th Amendment. There is no Equal Protection Clause anywhere in the Constitution that applies to the federal government, but the Supreme Court, by judicial interpretation, has read the Due Process Clause of the 5th Amendment to apply equal protection principles against the federal government. This process is sometimes called reverse incorporation. The most famous example of it is in a 1954 case called Bowling against Sharp. That's B-O-L-L-I-N-G, against Sharp, Sharp with an E at the end. That was a companion case to Brown against Board of Education. So remember, in Brown against Board of Education, the Supreme Court says that racially segregated schools are unconstitutional as a violation of the Equal Protection Clause of the 14th Amendment. Bowling was a case involving de jure racial segregation in the Washington, D.C. schools. 14th Amendment doesn't apply to Washington, D.C. because it's a federal entity. The court nonetheless applied the same rule to the District of Columbia, saying this was a violation of due process under the 5th Amendment as well. And pretty much more or less since then, there are a few variations, but more or less since then, the equal protection principle has been rendered applicable to the federal government as well as the state governments. Okay, so that's why citizenship matters. Now, I don't know if any of you read the New York Times story about the plan or other stories about the plan to step up the denaturalization. You can only take away somebody's citizenship if you show that they committed fraud in applying for citizenship. And fraud doesn't simply mean that they made a mistake on their application. It has to have been deliberate and material and so forth. So it's not clear to me that they will get that many more denaturalizations, although they'll certainly make life very uncomfortable for a lot of people. But the thing is, once somebody's status is reduced to permanent resident, right, permanent is a bit of a misnomer because, as we've seen in a number of high-profile cases, probably the highest profile is the Mahmoud Khalil case, right, that the Secretary of State can essentially revoke somebody's visa on the basis of a finding that their continued presence in the United States is against the foreign policy interests of the government. And so that allows, if you imagine what could be going on here is a kind of two-step process. Is first if they're able to prove fraud, they strip somebody of their citizenship. That knocks them down back to permanent resident, if that's what they were before, and then they could make the subsequent finding. And that doesn't lead to quite as much robust judicial review. So that is why I think citizenship is a big deal. All right, that's why citizenship matters. Where does it come from? Well, the original Constitution does not contain a clause setting out criteria for citizenship. It does have the following language, however. That's Article 1, Section 8, gives Congress the power to establish, I don't know why, maybe the pronunciation used to be uniform, but an uniform rule of naturalization. That's a rule of naturalization, right? So that tells you how someone can become a naturalized citizen. You might wonder, well, what about people who were just born here in the United States before 1868? They didn't have to be naturalized. And that's right. We had birthright citizenship in the US even before the 14th Amendment, but it was under common law. So common law is the generic term for judge-made law. It's basically the law that has been applied by custom and tradition for generations, going back to England, under a principle of what's sometimes called jus soli, or soli. My Latin's not very good. There are basically two kinds of legal systems for conferring citizenship. Jus soli meaning if you are born in the land, and jus sanguinis, so it's like the word sanguinary, it's by blood. And the common law countries have tended to have the jus soli system. And so it was just accepted that people born in the United States were citizens if they were white. And that wasn't just a common law rule. This is the language of an act that Congress passes, 1790. So this is right after the Constitution gets going, right? This is the naturalization law, right? So notice it's very generous to white immigrants, right? If you resided within the jurisdiction of the United States for 2 years, you could apply to be a citizen. Doesn't say anything about how you got here, right? We had open borders, more or less. So basically, people who arrived, if they were white folks, they would become citizens. And that was the law that Congress passed. There were some other provisions in the law. One is that it provides for citizenship to children of citizens. Now, if they were born in the United States and white, they got it automatically, but this is how children to US citizens who were traveling somewhere else outside the country when the child was born, this is how they acquire their citizenship. And as I mentioned, right, the common law provided for citizenship to white persons born here. Yeah?
Does this mean specifically no citizenship for non-white people?
So that's a great question. So the common law is not codified. It's sort of state by state in some respects. So free blacks in the United States, in some states, were citizens. Generally, they were in the North, not so much in the South. There were fewer free blacks, although there were some. New Orleans, especially after the Louisiana Purchase, has a lot of different people of mixed races. It's only when we get to the Dred Scott decision, which we will get to, that the Supreme Court says, no, none of that's true. And the Supreme Court says that black Americans, regardless of whether they were enslaved or free or anything else, were not and could never be citizens. That's the sort of, but that's not.
This act excludes naturalization of non-whites or not?
It does, but if there were free blacks born in the United States, under the common law of Massachusetts, say, they could be citizens. But it varied a lot from place to place and time to time. Okay, there's a 1795 Act that cleans up a few details but maintains the sort of racist character of early immigration law. All right, so now I'm going to skip forward to the eve of the Civil War. So this is the infamous decision in Dred Scott against Sanford. So Dred Scott was enslaved and his enslaver, who was a doctor, took him on a trip with him to Illinois, which was a free state, and they also passed through Wisconsin, which was at the time part of territory that wasn't yet a state. But the Missouri Compromise, which had been was an act of Congress earlier, had forbidden slavery in Wisconsin. And Scott argued that he was therefore free and could not be returned to slavery, because there's a sort of principle under international law and sort of general law principles that if you bring somebody from a place where slavery is the law to a state where a place where it isn't, then that person, you've emancipated them, at least if you take them there voluntarily. That was considered a general principle of law, but the Supreme Court rejects it. The Supreme Court says, no, that's not the way it works here in the United States. First, they say that insofar as the Missouri Compromise forbids slavery or purports to emancipate people who were previously enslaved, it is a violation of the Fifth Amendment of the Constitution. Remember, I mentioned it earlier, because it deprives people, namely white enslavers, of their property, namely their enslaved persons, right, without due process of law. So that is the sort of essence of the Dred Scott decision, right? It therefore denies Congress the power to have abolished slavery in the territories. It turns out the invalidation of the Missouri Compromise is not all that significant in terms of its legal effect, because it had been superseded a few years later by a federal statute called the Kansas-Nebraska Act. But this part of the decision is certainly important. Tawney goes on to say, and this is what we were saying earlier, right, that black Americans were not US citizens. How do they confront the language of the Declaration of Independence? Well, there's this remarkable sort of backwards logic in which the court says, well, obviously the framers of the Constitution, the signers of the Declaration of Independence, couldn't have meant to include enslaved blacks among all men who are created equal, because if they did, then they would have been terrible hypocrites. And we know they weren't terrible hypocrites, they were great statesmen. So there's this kind of, cognitive dissonance about the whole thing. And so there's this, so Dred Scott, and the remarkable thing about Dred Scott is that it's received by people who think, this is now going to settle the slavery question. President Buchanan had this view. He thought, well, the court will decide this, we won't have to worry, and we'll avert civil war. And of course, it did nothing of the sort. It hastens the Civil War. So that's where things stand on the eve of the Civil War. Of course, along comes the Civil War. Eventually, it ends. Confederacy is defeated. And immediately upon the defeat of the Confederacy, the Congress proposes and the states under military force, essentially, ratify the 13th Amendment, which abolishes slavery. But there's a worry that that doesn't go far enough, because very quickly, I apologize to those of you who are history buffs and know all of this, right? Very quickly, most of the states of the former Confederacy adopt what are called black codes that essentially institutionalize slavery in all but name. They're basically prohibitions on black people appearing in public, except in accompanied by a white employer. An employer is a sort of euphemism for a person who's effectively still holding them in slavery. And so Congress passes a whole bunch of legislation to make all of this illegal. And can do that because they think, well, we're the federal Congress, federal law is supreme, it displaces contrary state law. But they are worried, and with good reason, that not only is Andrew Johnson going to veto what they pass, because he does, and then they have to override his veto, but they're also worried that the Supreme Court is still a pretty conservative institution, and it might strike down some of this legislation. And so they adopt the 14th Amendment, which includes that language we've been discussing, right, the Citizenship Clause and the Due Process, Equal Protection, and Privileges or Immunities Clause, but also, crucially in their view, includes Section 5. And what Section 5 does is it empowers Congress to enact legislation enforcing Section 1. That is the driver, historically, of the 14th Amendment. It's an effort by Congress, then ratified by the states, again, under Reconstruction occupation, but nonetheless. The aim is to give Congress the power to enact civil rights legislation and have it upheld by the courts. I think we know the rest of the story, right? Which is they do that, it works for a while, then in the resolution of the election of 1876, there's this compromise by which Hayes, who is the Republican, gets to take office, and Tilden concedes, but at that time, Republicans are the party of Reconstruction. They end Reconstruction and occupation. Jim Crow is implemented, and the 14th Amendment, at least for its original purposes, becomes something of a dead letter for another 80 some odd years. Not entirely, but in many respects. But all along, there's that language, right, about all persons and citizenship. And it does expressly overrule Dred Scott's racialized notion of citizenship and those early statutes which made citizenship, the statutes have their own story, but the key is that for birthright citizenship, at least, now Dred Scott is gone, and so it's going to confer citizenship on the freedmen and women, but it's not just them, it's all persons born in the United States. Now, I'm going to get in a little bit to that last phrase, and subject to the jurisdiction thereof, because that's where all the action is going to be these days, but that's what I wanted to highlight for now. Yes, question?
Sorry to ask, but is there any mention up to this point of Native Americans?
Not in, right, so under this language, right, the question is where do they fall? We will see in just 2 slides that under the common law, Native Americans are considered not US citizens because they have tribal citizenship. In 2 cases involving Cherokee removal in the early 19th century, Chief Justice John Marshall refers to tribes as dependent sovereign nations, right? And they have that status, but then you say, well, what about people who are assimilated and so forth? And it's unclear for a long time, except that, as I'll suggest, the court in the Wong Kim Ark case gives us the definitive answer. And currently, just in case you're wondering, currently all Native Americans are citizens because there's a statute that confers citizenship. But they are considered excluded, I mean, if they're living within a tribal community, they're considered excluded from that from the birthright citizenship of the 14th Amendment by that subject to the jurisdiction thereof language. Okay, we're going to get to that soon, I promise. All right, so now we're in the latter decades of the 19th century. There is now starts to be substantial immigration to the United States from Southern and Eastern Europe, but also from China. Many people come to the United States basically under conditions of practically involuntary servitude, but they're working mostly out west, and this leads to a backlash in Congress, especially during periods of economic downturn. It's not that different from today when whenever there are economic hard times, immigrants are scapegoated. And this leads to the first and most important Chinese Exclusion Act, right? This is all the history I was giving you before, and so there's the key language, right? It does 2 things. It absolutely forbids Chinese immigration for a decade, and in addition to that, says no state court or court of the United States shall admit Chinese to citizenship, and all laws in conflict with this act are hereby repealed, right? So it makes it impossible for persons of Chinese descent to become citizens of the United States, except we want to ask, but what if they were born here? And that's going to tee up the next case. But before that, I just want to point out this exclusion was not repealed until 1943. And the impetus for repeal in 1943 is essentially that China, to the extent that it's not occupied by Japan, is allied with the United States in World War II. And so it's a kind of foreign policy move, less than a kind of realization of that this was a terrible wrong. All right, just to give you, to sort of close that loop. So US immigration law no longer has any explicit racial categories, but you might think of it as racialized in operation, because there's a cap of 7% of the total immigrants that can come from any one particular country. And so you can imagine, right, if you're coming from a small country, like, I don't know, Wales or Ireland or Norway, then you're not going to bump up against that 7% cap. But if you're coming from a very populous country, or one for which there's a lot of demand for people to immigrate to the United States, or I guess they'd be emigrating from their countries to the United States, that cap could be salient. And so in operation, this imposes limits. And then there are all sorts of other limits that make it, that basically severely constrain legal immigration. Okay.
Means what?
So however many total immigrant visas are being given, no more than 7% can come from any one country. That's current statutory law. Okay, now the key case, United States against Wong Kim Ark. Wong Kim Ark is born in the United States in San Francisco in 1873. His parents were living in the United States. They were not eligible for naturalized citizenship because of the Chinese Exclusion Act. He takes a trip to China, and then he comes back, and they deny him re-entry because they say, we're not allowing Chinese here. So what are you talking about? I'm a citizen. So the case goes up to the Supreme Court, and the question is Wong Kim Ark a citizen? And the Supreme Court says yes. He is a citizen because they can read the 14th Amendment. After all, he was born here. He falls within the Citizenship Clause. The court has a very long opinion, but the part of it that's most relevant to us is what it does with that language and subject to the jurisdiction thereof, right? Because that suggests, well, in order to have birthright citizenship, not only do you have to be born here, you also have to be subject to the jurisdiction of the United States. So the implication is that there are some people who are born here but are not subject to the jurisdiction of the United States. And what the Supreme Court says in Wong Kim Ark is, well, that language picks up the common law understanding as supplemented by the legal status of Native American tribes, right? That members of tribes were tribal citizens, that's different, so they're not subject to US jurisdiction because they're subject to tribal jurisdiction. But the exclusion only applies to these other two categories: children of diplomatic representatives of a foreign state, ambassadors, consuls, etc., and children born of alien enemies in hostile occupation. The idea would be, if we're fighting a war and the foreign country occupies part of the United States and they bring with them some pregnant people who give birth, those kids are not part of the United States because they're not subject to our jurisdiction. They are subject to the jurisdiction of the occupying army. And that's it. That's what the court says. That's all that means. Doesn't apply to Wong Kim Ark. And there things stood until January 20th of this year. Yeah.
So the children born of alien enemies in hostile occupation, or the children that are born here, what kind of proof did they need to present to show the child was a U.S. citizen?
So if they're born to an alien, enemies in occupation, they're not U.S.
No,
citizens.
they're not, right, sorry.
Okay. Correct.
So during the World War II, the children of Germans were not.
Well, if they were the children of German soldiers who occupied the United States, but the United States was not occupied in World War II.
Oh, you have to be open.
Yes. Yeah.
Oh.
Yeah.
That's never happened.
Correct.
It's never happened.
Right.
That it's a proviso.
Yes, it's a I mean, it might have happened in medieval England or something like that, right? So, but that's the understanding of it. Yeah. Okay. So that's where the law stood, and I should point out. Yeah, go ahead.
I'd like to make a comment about the exclusion of Chinese.
Yeah.
I find ironic that they decided to exclude people that have a 3,000 at least year culture.
Of course.
Much higher than the United States or Europe, I guess.
Yeah, not just ironic, almost predictable. So Congress can, of course, supplement the citizenship provided by the 14th Amendment, and as we've seen, they've done stuff like that even from the very beginning. Congress supplemented the common law because Congress has this power to prescribe naturalization rules. And so I wanted to highlight a few ways in which they've done that. So this is a federal statute. You can look it up if you want, 8 U.S.C. section 1401. And it says, the following shall be nationals and citizens of the United States at birth. So Congress is defining who is a birthright citizenship, who has birthright citizenship, right? And Section A simply restates the rule of the 14th Amendment. I'll come back to in a moment why that's significant. Section B provides for citizenship to Native Americans regardless of whether they live on reservations or otherwise. And so that knocks out, as a practical matter, that exclusion under Wong Kim Ark. And the key thing I want to point out is that Section A is enacted in 1940 and reenacted in 1952. And you might wonder, well, why does that matter? The reason why it matters is because when Congress enacted that statute, everybody understood that the language from the Birthright Citizenship Clause of the 14th Amendment had been authoritatively construed by the Supreme Court in Wong Kim Ark. And so they're using the language subject to the jurisdiction thereof in exactly the same way that the Supreme Court did in Wong Kim Ark, which was that only includes those 3 exclusions. And by the way, we're knocking out one of those exclusions in subsection B. This is important because even if the Trump administration could successfully argue that the Supreme Court in Wong Kim Ark misunderstood the history and got that language wrong in terms of its meaning under the 14th Amendment, so what? Because now that meaning was implicitly adopted by Congress in the statute, right? So it's as if the statute says, we are reiterating, as a matter of our power under just to enact statutes, the meaning of that limited exclusion given in the Wong Kim Ark case. Maybe they're right, maybe the Supreme Court was right, maybe it was wrong, but that's our understanding as well, and so that's how the statute should be construed. And I just want to say that the government's arguments in the cases that I've looked at almost completely ignore the statutory proposition. Okay.
What about Puerto Rico is I don't know, I can't remember. And then,
Puerto Ricans are U.S. citizens.
and then there are other territories.
Yeah.
that we-
Marshall Islands.
Right,
Marshall-
Marshall Islands, the U.S. Virgin Islands.
All those are citizens.
Well, so no, it depends. It depends on what in the United States means. If Puerto Ricans so they don't have, if they're the citizens, you think, well, they get to vote, right? But they don't vote in, U.S. elections, although that was true of residents of D.C. until we got the constitutional amendment to allow for that. So territories are a little different, but yeah. You could do, so when I teach constitutional law, traditionally we haven't talked much either about who is a citizen or about the territories, but I'm now thinking that maybe the next time I teach it, I'll have to dive more into it.
And the voting, I mean, the DC, they had Eleanor Holmes Norton, but.
Well, she doesn't have a vote.
Right, that's.
No, but in presidential elections, they can vote.
And they didn't.
Right, until we got a constitutional amendment to do that, yeah. But yes, question.
I thought Puerto Ricans who live in the U.S.
Yes, if they live here, they can vote in the U.S. They're
vote.
regular citizens.
Right.
Yeah, it's just if you live on the island, you could vote in local elections, but not
That's good.
Congress or president. Okay, I think I'll move on to the more recent stuff, right? So I just want to say that 1924 is the date of the Provision B, which grants Native Americans citizenship regardless of where they live or were born. Okay, so almost immediately upon taking office again this year, President Trump issues this order, right, protecting the meaning and value of American citizenship. And here's the key. So you can read this, or you can just rely on my summary. Basically what it says is, you get birthright citizenship if, but only if, one or more of your parents is actually a citizen, in which case you don't need birthright citizenship because you get it by statute, or a permanent resident, right? But if your parents are here either on a student visa, tourist visa, work visa, or they're entered without documentation, you don't get citizenship. Now, one of the few things about it that was, not as bad as it could have been, is that it was made prospective only, right? So it was for children born after a certain date in February, which now is passed, but it was immediately challenged and enjoined. I'll get to that in a moment, but I want to point out that notice that the executive order itself could have been phrased in the way I described, right? Which is to say you only get the citizenship if your parents are this, that, or the other thing. But they actually divided up into two separate categories. So part one says no birthright citizenship if your parents are undocumented. And section two says none if you don't have, even if your parents are lawfully present but not permanent resident. Okay? And I'll explain in a moment why I think they split it up that way, but that's what the order does. All right, so it's immediately challenged by multiple lawsuits, and you may recall, so every judge to address this says that the...
How do they challenge it if it doesn't go into effect?
It was scheduled to go into effect in February. It had a date certain. You're allowed to bring a lawsuit for injunctive relief, meaning a court order saying don't do this, for something that is certain to happen in the near future. Yeah?
Who wrote this? It wasn't Trump, obviously.
So I assume it was some lawyer working with Stephen Miller. Stephen Miller's not a lawyer,
Yeah.
but so one thing I'll say about the Trump executive orders this term as opposed to his first term is they're different in three ways. First is they're much more radical in what they're trying to do. Second is they tend to be more rhetorically excessive. That is, they sort of say, that they sound like Trump's social media posts. But three, they tend to be smarter. That is to say, well, yes, that's true too. Right. But they, even though I don't like them, I have to admit that this time they seem to have had lawyers who know something writing them in ways that don't make them legal, but make them hard to challenge in some circumstances. Okay, this one, though, is not that hard to challenge. And as I said, every judge who, regardless of whether they were appointed by a Democratic president or Republican president, every judge who faces it says this executive order is unconstitutional, you can't enforce it. The Supreme Court last spring heard one of the cases, but only on a procedural question, right? You may remember this is a case called Trump against Casa, and the question was whether when a federal district judge finds that the federal government has acted or is planning to act unlawfully, the judge can issue an injunction, an order against the enforcement of the president's policy that benefits not only the particular plaintiffs in the case, but also everybody who might be affected by it. And the Supreme Court in Trump against Casa, without addressing the merits, says, no, you can't do that. They say that the judge can only order relief, that is, remedy, for the plaintiffs and non-parties to the extent that that is necessary to grant full relief to the parties. Now, just to give you an idea of what that means. By the way, I should say, although I disagree with this, I don't think that's a crazy rule. I think they've misapplied it, but I think it makes some sense. Generally, if a plaintiff sues a defendant for some sort of order, the order runs against the defendant for the benefit of the plaintiff. If somebody else has a similar complaint, they have to bring their own lawsuit, right? This exception, except to the extent necessary to grant full relief to the parties, that's designed to deal with cases where in order to make the thing effective, it's got to apply beyond the immediate people here, especially where, as here, it's brought on behalf of a few pregnant people, but you might go to another state. So I'll give you a good example that arose during the first Trump administration. So you may remember in the early days of 2017, they issued the so-called travel ban, right, a Muslim travel ban, right? And it immediately led to lawsuits. Eventually, after it was modified twice, the Supreme Court upheld it. But before that, a number of judges struck down the earlier versions. And one of the judges, anticipating the Supreme Court's rule in Trump against Casa, this was long before it, says, look, I'm a judge in Washington State, but I need to enjoin the government from enforcing this throughout the whole country in order for people from foreign countries to travel to Washington State, because I don't know where they're going to enter the country. They could enter in LAX and then take a plane to Washington. They could enter at Kennedy Airport. And so in order for me to grant complete relief to the people in the state of Washington, I've got to issue an order that applies to the federal government everywhere as to everyone, because I don't know who's coming to Washington. Whether that falls within this exception for granting relief to the parties, we don't know, because the administration changed the order a couple of times and that issue wasn't litigated. But that's the idea here. Now, the reason I say Trump v. Casa was, in my view, wrongly applied is that I think that that's true of birthright citizenship, right? So if New Hampshire is trying to, is worried that somebody in our state is going to, we don't know who's going to be a citizen or not, right? They don't know when people who are, somebody born in Massachusetts moves to New Hampshire, in order for the birthright citizenship to be effective, the federal government has to be enjoined anywhere somebody could have moved from, which includes the whole of the United States. So again, I think you could have made that argument here, but the court doesn't deal with it. But they do recognize another potential very large exception, and that is that plaintiffs can file a class action. Class action, you're familiar with, right? This is the idea where plaintiff files a lawsuit not simply on their own behalf, but on behalf of other people similarly situated. There are a bunch of complicated federal rules that govern when you can bring a class action, who gets to bring it, and so forth. But take my word for it, I've taught this stuff many years, right? This is a classic case of what's sometimes called a Rule 23B class action. That is to say that the government has taken action in a way that affects an entire class of people, such that it's suitable to get an injunction against them. So here the idea is you bring a class action on behalf of all children who may be born to people who fall within that executive order who would otherwise have birthright citizenship. You get certified and you represent the whole class. And that's exactly what happened in a number of places, including federal district court in New Hampshire, where the federal district judge certified, yeah, this is a good class action, at least provisionally, and then enjoined the enforcement of the executive order. And then a few weeks ago, the Supreme Court said, it said, we would like to hear this case. The Solicitor General, the Department of Justice, asked the court to review it and took the case up to the Supreme Court, and the Supreme Court has agreed to hear it. They haven't yet scheduled the argument, but it'll be sometime in the next few months. Okay. Right, so that's the New Hampshire one, and that's the one that's pending in the Supreme Court. All right, I want to say a few words about why I think the outcome should be, well, it should be obvious since what I've said already, but I just want to make two basic arguments, right? So first, the Solicitor General has a theory that subject to the jurisdiction thereof means owing loyalty to. Now, you can find like passages taken out of context from 19th century and earlier materials that suggest something like that. But the problem with it is that the child doesn't owe loyalty to anybody at the time that they're born, right? Infants aren't loyal to anybody, right? It's not about loyalty. Subject to the jurisdiction thereof means who gets to regulate them. Now you can see why the US government wouldn't get to regulate children born to occupying armed forces or to children born to ambassadors because they have a kind of extraterritorial status, but everybody else is subject to US jurisdiction. It might be that their parents don't owe loyalty to the United States, but that language, subject to the jurisdiction thereof, in the 14th Amendment is a qualifier of the people who are born, not their parents. So that's just a kind of linguistic problem with the Solicitor General's reading. The other thing is that it's possible to distinguish Wong Kim Ark on its facts, but not quite the way that the Solicitor General does. What he says is, look, Wong Kim Ark doesn't cut against us because Wong Kim Ark's parents were permanent residents. Now that's anachronistic. They were not permanent residents. They were, in the language of the Supreme Court in the case, domiciled and resident in California, but the status of permanent resident, right, a green card holder, doesn't come into US law until much later. All that this means is they were present in the United States lawfully, but so are people who aren't permanent residents who might be here on tourist visas, et cetera. But this does allow, I think, a distinction to be drawn on the facts of Wong Kim Ark from children born to undocumented immigrants. I think that I have to concede that to the Solicitor General, that the facts of Wong Kim Ark are different from a case of children born to undocumented immigrants. But Wong Kim Ark doesn't just stand for its facts, it also stands for that key language about what subject to the jurisdiction thereof means. And, as I indicated earlier, right, Congress took that understanding for granted when it adopted the statutes that incorporate the Wong Kim Ark principle and the language of the 14th Amendment. Right? So that's all why I think the government should lose the case. Somebody asked me to predict. I will say I do think the government will lose, although I wouldn't bet a lot of money on it, but I think they will. I think the government will lose. Partly because I'm not sure that they're taking the case signals very much. They almost always take cases when the Solicitor General asks them to, and here the plaintiffs didn't really object to the Supreme Court resolving it because they think they're going to win anyway. So I do think that there's a good chance the Supreme Court rules the right way, although I'm not 100% certain of that or anything. I want to conclude, before I move to questions, with one thing that is not in my outline, and that is sort of the normative argument for birthright citizenship. So the United States is pretty unusual in having birthright citizenship. Even countries that are part of the same common law tradition don't have quite as open birthright citizenship as we do. So in Canada, for example, if you are born to non-citizen parents in Canada, you are a citizen only if they're permanent residents. You don't get citizenship just by being born to a tourist in Canada. And so you might say, well, what the federal government is asking for is, it's not such a crazy thing. It's not so anti-immigrant. We don't think of Canada as a, uncivilized place. It's true of a lot of other places. Many countries in Europe don't even give any kind of birthright citizenship. They have citizenship going with blood. And so I think there is a sense in which that's right. That is to say, viewed in sort of global perspective, the Trump administration's position is not an outlier. But I do want to suggest that the birthright citizenship provision, in its broad understanding, as understood in Wong Kim Ark, and I think under its plain text, has something about it that does cohere with American values. And I'll just point to two other provisions of the Constitution that seem to be of the same spirit, or I guess technically three. So Article 1, Section 9 imposes a bunch of limits on the federal government. Article 1, Section 10 imposes some limits on the state governments. Neither of them, so this is a provision that appears in both Section 9 and Section 10, says neither the federal government nor the states can grant titles of nobility. Okay? You might wonder, really? What's that doing in there? Well, I think it suggests the sort of deeply small d democratic roots of the US Constitution. Now, think about Section 3 of Article 3 of the Constitution. So Article 3 is the part that sets out the federal judiciary. Section 3 is about treason, and it says you can punish treason. Congress can create laws punishing treason, but no law may work, quote, corruption of blood. Corruption of blood was an English practice by which people convicted of treason could not pass on anything by way of inheritance. So it disinherited the children of traitors. By the original Constitution forbidding titles of nobility and corruption of blood, I think you can see a broader principle that says that children shouldn't be held responsible for what their parents did. And that's a principle that I think has deep appeal. It's small d democratic, right? And that you see it in some places even in US Supreme Court case law. So there's a case from about 40 years ago called Plyler against Doe, in which Texas said that children of undocumented immigrants couldn't go to public schools. Supreme Court in the Plyler case said that's unconstitutional. It's unconstitutional because Congress hasn't chosen to forbid this, and Congress has the primary power over immigration. And also, essentially, why are you punishing these kids because of your beef with their parents? And so I think that there is a normative case. I don't expect this to be made in the Supreme Court. I expect the arguments to focus on the 19th century history and whether Wong Kim Ark was right and what it means and all of that. But underlying it seems to me to be a profoundly democratic impulse, which, even if an outlier globally, is something that the United States should embrace as a so-called nation of immigrants. Okay, that takes me to the end of the affirmative presentation.
Why Kim Ark go down to China and then come back here?
Yeah, that's why they didn't want to let him in. That's why it is. Okay, question, yeah, back.
If the court decides in favor of the Trump administration, will that decision also resolve the Legislative Act issue, or will that require another suit to go through the courts again?
So the short answer is no, it wouldn't. I mean, it could. So One scenario in which the Trump administration wins would be that they get overruled then by Congress, right? Congress, I mean, obviously Trump would veto any act that would try to reverse this, but if you imagine a future in which you have a different Congress and a different president, even if the Supreme Court upheld this executive order, it would be possible to have that reversed by Congress.
I don't mean that. I mean the legislative part of the argument there where the law was passed that these people are citizens affirming that earlier Supreme Court decision. If the Supreme Court now decides that constitutionally they agree with Trump, does that also decide the legislative?
Oh, no, I don't think so. So that's the point of my argument. My argument is that the plaintiffs can win either by showing that they're right on the meaning of the Constitution, or by showing that even if they're wrong about the meaning of the Constitution, the meaning that they attribute to the Constitution is the meaning of the statute. Now, one question you might wonder is, well, how can the same words mean one thing in the Constitution and something else in a statute? And the answer is that happens all the time. So there are numerous, I could give you numerous examples of Congress copying language, well, I'll give you a few examples. The Congress copying language from the Constitution, and then the statute doesn't mean the exact same thing as what the Constitution meant, because Congress had a different purpose, or Congress was relying on a judicial understanding, and that gives it a statutory meaning, but not a constitutional one. Other questions or points you want to discuss? Yeah.
Because I'm not understanding, so if someone's here illegally, right now, are they considered under the jurisdiction of the United States? So if you pass this, does that mean that like an illegal immigrant can get a speeding ticket because they're not under jurisdiction of the United States?
Right, so this is part of the argument against the Solicitor General's proposition, right, which he says, well, they're not citizens because they're not subject to the jurisdiction of the United States. Okay, well then how is it that we're applying our laws to them, right? The SG's argument is, well, subject to the jurisdiction thereof doesn't mean that we apply our laws to them. It means they owe us their allegiance. And so it's possible that we could apply our laws even to people who don't owe us their allegiance. I don't think it works, again, for the reason that I identified, which is that it's modifying the wrong part of that sentence, but that's their theory. But I do think you're right? Especially when you read what the Wong Kim Ark case is actually saying, which is subject to the jurisdiction thereof really means we're applying our law to them. We're not applying our law to ambassadors and their kids. We're not applying our law to an occupying army if they were here, because we wouldn't have the ability to do so. And so I do think that suggests that the language pretty much means what it seems to mean on its face. Well, yeah.
So I listened to Amicus, it's a podcast, and they just had on Cheryl Lynn Eiffel, who her argument is that this administration is going after gutting the entire 14th Amendment. And I just wondered what you thought about that.
So this is not to, I don't think she would disagree with this. So, but they're not gutting it to the extent that they think, for example, that it forbids affirmative action, right? They want to rely on the 14th Amendment insofar as it forbids discrimination against white people.
Right, okay, good point.
Yeah, no, not quite the entire 14th Amendment. Yeah.
This government seems to hold the immigrants to a higher standard than the regular American. Like now, there are rules to apply for citizenship, and I don't know, it's also for permanent residency.
Yeah, so there are a number of ways in which...
Is that fair? Is that in the Constitution?
Yeah, so I'll start with whether it's legal. So there are various ways in which the current administration is drawing distinctions between citizens and non-citizens that I think are unprecedented in recent times. So it's generally been understood that, for example, that non-citizens have First Amendment rights, right? First Amendment rights, right to freedom of speech. And yet, it's very clear that in revoking student visas, for example, the State Department has been singling out people whose speech it disapproves of. Now, that might not be challengeable because of the broad discretion conferred by statute on the Secretary of State. My own view, I'm not sure the courts would agree with this, but my own view is I don't care that the statute confers that jurisdiction, that power on the Secretary of State. Statutes are subordinate to the Constitution, and so if immigrants have free speech rights, you can't retaliate against them for exercising those free speech rights, and that includes by deporting them, even if they would be otherwise deportable for some other reason and don't have a right to stay. I think that's the right analysis, but that hasn't been how it's been playing out. So far as other things, one of the interesting things is, to become a U.S. citizen, you have to pass the citizenship test, which I think most people who are citizens by birth would not be able to pass. Certainly not without a lot of studying. And it's my understanding that that the administration wants to make the test more difficult. So there are many ways in which immigrants are non-citizens are held to higher standards. Is it fair? No. But there are. That's not to say that I don't think the government could draw any distinctions at all between citizens and non-citizens, but the kinds of distinctions that are being drawn now are, they're targets of opportunity, and they are scapegoats.
They also block people from going in this was like a couple of days ago. They wouldn't let ICE wouldn't let people go in to say the pledge or to do. I can't.
Well, right. So this is one of the worst things is the use of ICE and other law enforcement entities to arrest people for purposes of putting them in immigration detention and possible deportation when they are in the process of going to court appearances. And it totally undermines the effectiveness of the whole legal system, right? Which is you want people to go to follow the rules, and then if you undermine that by arresting them. Yeah, back.
Yeah, I was going to say, so this is a big question because I keep getting it from my students, and so I'm trying to answer it myself as well. In order to define who's an immigrant and what the rights and procedures for immigrants are, understanding citizenship, and they'll be like, well, where do we go today? The intersection of these executive orders, the legal or illegal, depending on your perspective of the Trump administration's actions. And if you went online and just looked for, what are the immigration procedures, and they're neatly defined and what to do. So how do you respond to one, where do you go to find out what's there, which may or may not be respected, and then what is the executive order's connection with already congressional law and procedure?
Right. So let me try a few different cuts on that. So first, an executive order, as a technical matter, doesn't create law. It is a directive from the president to other people in the executive branch, right? The reason why you might say, well, it doesn't create a law, who cares? Well, it's because people are acting on that, and that's why you get an injunction, right? The injunction is against the action that the executive order is directing these other people to take. But the hierarchy is the Constitution, statutes that are passed in accordance with the procedural rules in the Constitution that don't violate anything in the Constitution, and under that, executive orders to carry those out. If the executive order is not authorized by the statute, or if it violates a statute, or if it's not authorized by the Constitution or violates the Constitution, then it's not valid. Now, saying it's not valid is not the same thing as saying it won't have any effect. So the Oliver Wendell Holmes Jr., in a very famous passage in a book he wrote before he became a Supreme Court justice, wrote that the way to think about the law is from the perspective of a bad man. He says that a good man, or good person, right, doesn't need the law. A good person does the right thing because they have a conscience. He says the point of the law is to deter or reward, or deter bad behavior and reward good behavior by setting up consequences. So you think about somebody who doesn't care about doing the right thing. All they care about is what they can get away with. And so the point of the law then is to constrain them. I think we now have an administration that is effectively Holmes's bad man, right? That is, they are not constrained by any sense of obligation to the law, certainly not to any principles of morality. And so the question is what they can get away with. And this is why, by the way, when I'm asked, what do I think is the most dangerous thing that the Trump administration has done, my answer is always flirted with disobeying court orders. Because that's the only backstop you've got against this. Because if you don't have that, you don't have anything. Now, that doesn't mean that's the only thing that worries me. What also worries me is that courts, especially the US Supreme Court, being, acquiescing to a great extent in what this administration is doing. I think the federal district judges have acquitted themselves pretty well. Federal appeals courts sort of in between, but the Supreme Court has, with a few exceptions, green-lighted this. And there, I think probably the worst thing about those decisions is that they're treating the Trump administration like a normal administration, like this is, Barack Obama or George Bush or somebody who has some, sense of and is surrounded by people who care about what the law is.
What's going to be then? I mean, here the court is supposed to represent a certain way of.
Yeah. So
and he just whatever they say, he does the opposite.
Well, he hasn't. Right. So he hasn't yet directly defied the Supreme Court, although he came pretty close with respect to some of the removals of the Venezuelans to El Salvador. There were, there was, you may remember, in one of the cases, the court said that, well, you have to give them an opportunity to file habeas petitions, and there has been kind of soft defiance of that, but they haven't. I count it as a tiny reassurance, not much, but a tiny reassurance that neither Trump nor Bondi nor anybody in the administration has yet said we don't have to follow the Supreme Court's orders. What they've said is we are doing so, and then they give some tendentious explanation of what they're doing. But I do think it counts for something that they don't want to admit to directly defying the courts.
And they're shipping all those people out to Uganda and all places there.
Yeah, that's actually true. Yes, then here. Yeah.
So if parents would lose their citizenship and the children have citizenship just by virtue of the parents being citizen and they were born abroad, for instance, would the children then also lose the citizenship or not?
Yeah. So you're talking about if the executive order goes into effect.
Even in the current case, if somebody gets denaturalized.
Yeah. So if somebody's naturalized and then they have a child born here, they're all citizens. So.
Not born here. Say that people were naturalized and then they move abroad. And
I see.
Abroad,
right. So my understanding of how the law is written is that the children would then. So this is not about the executive order. This is about the denaturalization proceedings. Yeah, I understand. So I don't know of any case that involves exactly that. My understanding of the way the law is written is that children would continue to be citizens because they were citizens when they were born. Now, unless you say there's a Latin expression used in law called nunc pro tunc, meaning now for then. So you could imagine that denaturalization is nunc pro tunc. So you're not a citizen because you committed fraud, and therefore you were never a citizen. If you were never a citizen, how is it that you conferred citizenship on your children? I don't think that's the way it operates, but I couldn't guarantee that. Yeah, I should say that one of the things that'll be very concerning if the Supreme Court upholds the executive order is how one goes about proving that one has birthright citizenship, because it depends not only on having a birth certificate that says you were born in the United States, but also on the status of your parents, which is not recorded on the birth certificate. And birth certificates are typically issued at the county level. So it would require a massive change in the sort of, literally thousands of local bureaucracies to be able to even deal with this, the consequence of this. And I'm quite confident that nobody in the Trump administration has thought that through at all.
And don't say it in your lectures.
You had another question, sir.
I did. I'm wondering how many people this affects. I mean,
It's thousands.
not tens of thousands?
It might be tens of thousands, but it's thousands at least initially. But over time, it goes forward forever. So, eventually, millions. Well, it purports to.
But if a new administration comes.
Excellent question. Right. So right. So here's the question one might ask. So the way that the executive order operates is that it instructs executive branch members not to treat children born in this window under these circumstances as citizens, so they can't get passports, et cetera. But imagine that there's a different administration. Suppose Trump leaves office in January 20th, 2029, which is not a date I've circled on my calendar at all. And there's a sort of a president with a different view who rescinds this executive order, right? I think it's gone. That is to say, you might say, well, what about the kids who were born in between? It doesn't purport to, it decrees that they don't have citizenship, but it's not a statute. It's only instructions to the State Department officials about whom to issue passports to and so forth. And so you'd issue new instructions. So in that sense, maybe it's not of the damage that they're doing, it's not the most lasting necessarily.
So then the people that, if it would lose now, they could get it back under the new executive order.
Right, and they'd be 4-year-olds, they probably wouldn't even know.
But if Trump dies, you see, there's a lot of talk about his physical, mental health, that he's got Alzheimer's.
Well, if he dies, he can't run for re-election.
Right.
I don't really follow the news. Is Trump pushing through legislation that does some of the things that his executive orders are doing?
Yeah, so it's a really good question, right? That is, he's attempted on some fronts, not on the most aggressive things because, no, because nearly all of these things would require 60 votes in the Senate unless you got rid of the filibuster, and they don't have that.
He can't do much damage in the way of legislation.
Well, no, that's not true. I mean, there are things they can do without 60 votes through the so-called reconciliation process. So the so-called Big Beautiful Bill Act did that.
And the health stuff that's.
Right. There are lots of things that they're doing that Congress can do. And they can do a lot of things by not acting, which is sort of what they're doing now. Yeah. Any more birthright citizenship questions? Comments? All right.
Thank you
Thank you
for
all.
coming and talking to us.
My pleasure. Thank you all.